Welcome to PK Simply GST. I'm PK Singh, GST author, speaker, and practitioner. Dear friends, today we are going to discuss you about the Refex Industries Limited and Sherisha Technology Private Limited case related to Section 50, subsection 1. And everyone is concerned about that section because the taxpayers are receiving so-called notices to pay the interest on gross tax liability if they file their return after due dates. The department, GST department already started issuing the notices, so-called notices, charging interest on gross tax liability. In this regard, this judgment is very important, and it is why it is important, because it is giving a moral boosting to the taxpayer and the professional. Those are fighting कि whatever the government they are trying to do is not correct and not justifiable. Why? At the junctures of this 30 and 32 months of journey of GST, the intention of the government is not correct. I am not saying this. The Honorable Judge of Madras High Courts mentioned in that way. His words was different, but he want to say like what I am communicating to you, because he said that amended section 50 subsection 1 should be operational from retrospective effect. He also believed that it is clarificatory. Means the section, if you amend it, means you are clarifying that the errors was committed at the time of drafting of the law. So government accepted that, but here government is fighting that. Now you are receiving the notices, so-called notices to pay the interest on gross tax liability. What should you do? Obviously, you have to reply. Then file appeal. Even if you want, you can move to the court also. You can file writ petitions. And I hope that you need much time. Why? Because this matter will go to the Supreme Court, and once the Honorable Supreme Court will pronounce the judgment, then it will be binding of whole India. Until date, the taxpayer need time. I know that government will fight because the intention of the government is not correct since beginning. Why? Because 2019 budget, they amended section 50 subsection 1 proviso, but till date they are not notifying. Instead of not notifying those sections, they are tweeting, their officers, they are tweeting and justifying while quoting the case of mega engineering. But mind it, this mega engineering case is also mentioned while argument in this case of Refex Industries Limited. An honorable judge clearly mentioned that this mega engineering case judgment was at the time when this particular things was through the press note. GST Council discussed, but it was through the press notes. That's why the judgment was based on the press note. But now the section is amended. Just it is not notified. Amended means the government accepted that it was errors, and this we will accept as a clarificatory. Secondly, they are saying it should be retrospective because it is accepted that it was a mistake since the implementation of the GST law. So it should be implemented from very 1st July 2017, and most of the professional, they are agreeing with me that this must be retrospectively. I was also surprised when the up and co judgment came in the favor of the taxpayers, and the honorable courts mentioned that the GSTR 3 is not a return itself. Then the government immediately, amended the law, notify, and they said that GSTR 3 is a return. Now this budget also, if you will see that most of the provisions whichever in the favor of the government, they itself mention that it is applicable retrospective effect. Then why section 50 subsection or not? So dear friends, I am very much happy because last 1 year I was worried a lot about this because I'm interacting with the you know lot of peoples in the months, being, either they are my clients or the audiences, and they are worried a lot. And I knew that the honest taxpayers, they are worried a lot, and this particular section is discouraging them. Sometimes they are discussing that those are the frauders, they are enjoying, and we are the honest taxpayer, we are the paying the tax. At the same time the government is penalizing. And that's why I was, since the beginning I was fighting for this one, that this is not correct tax. And let me clear that I am not a political person, and I'm not against any political party or not supporting any political party. I'm just discussing about a provisions of section which is not correct, because the intention of the GST law while we drafted it was not to take the interest on gross tax liabilities, it was on net tax liability. So my dear friends, what you will do that now you have to reply to your so-called notice quoting Refex Industries case, Sherisha Technology Private Limited case. I think both are group companies, or might be same group company, because the address of the both companies is same. If you want to read more about this case, you can download the writ petitions number 23360 of 2019, 23361 of 2019, and you can read. This is a very fine points quoted by the honorable judge, and that is the reason they accepted the writ petition. But it was a very difficult task, because once the writ petition, first that so-called notice was issued by the department of the first company, Refex Industries Limited, and the order was mentioning nearly 11,65,000 interest to be paid. And in the second company case, namely this Sherisha Technology Private Limited case, this amount was nearly 23,62,000. And then this order was in May 2019, and then finally they went for the writ petition. They filed the writ petitions. At the same time, even the GST departments, they written to the bank for recovery of the interest. Then this writ petition was, two honorable judges were there. They have the different opinion. And then finally it might refer to the third judge, and honorable third judge finally went to and this conclusions came. And the conclusion was in favor of the taxpayers, in the favor of those professionals, though those are correctly interpreted section 50. What was the correct interpretation? Interest should be payable only if returns was filed after due date on net tax liabilities. And all those are correct. Still, I am very much hopeful that Honorable Supreme Court judgment will be also in the favor of the taxpayer, because courts also saying the intention. And I would like to request to the government side also, kindly consider this judgments, writ petition, not judgment, you can say that acceptance of the writ petition, and you will support the taxpayer. Taxpayer are suffering. Don't go on the computation of that you are going to receive the 46,000 crore. Mind it. This 46,000 crore, government will lose 2 lakhs crore, because we, as I mentioned, that we are day-to-day dealings and discussing with the taxpayer, and because of all these provisions, they are in worry. Who are worried? Taxpayers, because they are feeling that they are the honest taxpayers, and government is unnecessarily penalize them. And believe it, some of the dealers I discuss, their margin is 2 to 3%. And you are invoking various sections of the GST law, and then you are charging the interest. Ultimately, this indirect taxes is converting to direct taxes, because they are paying from their own pockets. And definitely, if that is not their fault, even most of the time, because initially people, taxpayer could not understand. Forget the taxpayer, even the professional, they were not aware about all of the provisions of the GST law. And apart from the technical glitches, still it is happening that. Though the government is not accepting, we can't say much about that, but the fact is that lot of returns was filed after due date because of the technical glitches of GST portal. I hope that in future some of the honorable courts maybe consider this point also. But the fact was that definitely due to the technical glitches, due to the lack of the expert, employees, most of the time the returns was filed after due dates. And it is obvious also because GST is just 32 months old, and even still a lot of professionals are struggling to understand the provisions of the GST. And I am hopeful that these provisions government will notify with retrospective effect. I am very much hopeful, and reason is that even the government know that interest should be computed on net tax liability, not on gross tax liability. So dear friends, fight it. I am PK Singh. My firm PK simply GST. We are with taxpayer, particularly, specifically for the provisions of this section 50 subsection 1, rule 36 sub rule 4. That is also, most of the cases I will discuss about that one, but that is also cannot be, that provision itself is, I'm not saying not in the favor of the taxpayer, but it's practically impossible. And taxpayers' working capitals will block. Not only that, they have to employ more people. A lot of issues will be there. I will discuss separately about Rule 36 or Rule 4. And then another is the Section 16 subsection 4. Separate video. I will discuss about all those things. With this, I would like to request you that you have to fight wherever the department is trying to harass you. We are respecting the department and government from the bottom of our hearts. They are also human beings, and sometimes they are working in the pressure. So I don't have any complaint against the departments. But I would like to request to the top officials that they have to understand that this country is getting revenues from the taxpayers. And we have to genuinely and honestly accept that if we will harass those honest taxpayer, then ultimately this is not good for India. That's the reason I'm against this interest on gross tax liability. And I'm expecting a lot of queries and suggestions regarding this section 50, and I must thank you to all of you to watch this video. Thank you. See you. Bye bye.